welcome to this lecture series, this section of the lecture series, Normative Production and Decision-Making Processes in the Roman Curia. We have today Isabelle Poutrin as a guest. I'm really happy to have her here in person. We are excited about her presentation. We read a couple of articles of her in the group, and this already developed a lot of questions and helped us a lot in discussing also topics that are very interesting to us. So welcome to all of you here in Frankfurt and elsewhere. I will give just a very, very short presentation of Professor Poutrin, and then she will present her paper, and we will have plenty of time later for discussing. So Isabelle Poutrin is Professor of Early Modern History at the University of Reims and an honorary senior member at the Institut Universitaire de France. In 1991, she obtained her PhD in history, supervised by Marc Bénard at the Université of Nanterre, Paris-Nanterre. The title of the dissertation in English would sound Contemplatives and Religious Powers, Autobiographies of Mystics, Inquisitorial and Hagiological Sources in Spain, 16th-18th century. And in the library of the Institute we have one copy of her book that I will circulate, and Anna will just put the title in the chat so everyone is informed. She then had a lot of work in teaching in different universities. In 2010, she submitted her habilitation to direct research at the University of Paris 4, which led her to appointment as university professor in 2017. From 2014 to 2018, she directed a project called POCRAM, de l'Agence Nationale de Recherche, Political Power and Religious Conversion, Antiquity to 17th Century, which resulted in several important publications. And more recently, she started the ERC project Rota Rome 17. It will started this year and will run until 2028. Focused on the Tribunal of the Roman Rota in the early modern period, as a tool for the governance of the Church and Catholic states of Europe. The project aims to give the Rota, a pontifical civil court and transnational jurisdiction, its full dimension as a historical object, commensurate with its importance in the relations between Rome and the Catholic states, the construction and systematization of canon law after the Council of Trent, and the Church intervention in Catholic societies. Her research is mainly devoted to the relations between religion, politics, and society in the countries of Southern Europe, and now also in general Europe in the 16th and 17th century. More in particular, she dedicated several studies to practices and theorizations of coercion and consent, like conversions, marriages forced into religion, and to religious minorities and women in Southern Europe. To mention just two of his books, in 2012 she published Convertir les Musulmans, a book on the conversion of Muslim and Moriscos in the 16th century Spain. And we have here the Spanish translation that came out in 2020, if I'm not wrong, also from our library. And in 2022, she edited with Elisabeth Lucet the Dictionnaire du Fuet et de la Fessée, corriger et punir, which is the result of a cross-disciplinary history project on the right of correction financed by the Institut Universitaire de France. And the work were awarded by the Prix Sade de l'Essai for the in 2022 also, right? Yeah. Moving between these several themes, Isabelle Poutrin has explored many different archives and sources typologies produced by many different institutions, archives of the Spanish monarchy, of the papacy, of other ecclesiastical institutions, archives of courts and tribunals, and many others. In her work, she was always shown a great interest in the legal and normative dimension, delving with the sensitivity of a social historian into topics often laid aside by the more classical history of law. In this process, her way of approaching the sources, be they archival or, for example, the writings of jurists of the modern age, is, in my view, of great example and inspiration, because she manages to combine the rigor and precision provided by her knowledge of the complex legal world, especially of the post-Tridentine legal world, with interpretative acuity and the fascination with the cases studied and the actors she deals with. While reading some of her essays, you really have the feeling that you are somehow kind in kind of a movie, but you have really all the tools to understand deeply why things were going like that in the past. So I'm really happy and honored that she accepted our invitation, and I'm sure that her paper today will give us a lot of food for thought. So welcome, Isabelle Poutrin, and the floor is yours.
Thank you. Do you hear me? Yes? Well, dear Professor Benedetta Albani, dear Professor Thomas Diouf, first I want to express my gratitude and pleasure for your kind invitation and for the opportunity which is given to me today to present a modest contribution to the program on the governance of the Catholic Church after the Council of Trent. I will share the results of a case study based on the sources of the Tribunal of the Roman Rota in the beginning of the 17th century. Result which will be soon published in a book, which will be published in next November, and which is called Les Convertis du Pape, une famille de banquiers juifs à Rome au XVIe siècle, by Édition du Seuil. Bon. Well, so my exposition of the case will be following the steps of my own research. I discovered the sources of the causes of the Roman Rota about 10 years ago, when I was beginning new research on consent and constraint, and more precisely on the legal notion of fear, metus, that could be alleged to obtain the nullity of religious vows and marriages. I wanted to test my hypothesis of two different regimes of consent in the 16th century, one for baptism and another for contractual acts, marriage and religious vows. Having noticed that the jurisprudence of the Roman Rota on these matters was often mentioned in various treatises, for example by Giambattista De Luca's Theatrum Veritatis, I began an extensive exploration of the printed volumes of decision of the Roman Rota, where I selected some cases which appeared to be particularly important in this jurisprudence. This research was all the more exciting as this material has not hitherto attracted much attention from scholars for the early modern period. Well, as the Roman Rota is not very well known, even among historians and specialists of early modern Rome, it seems necessary here to give some basic precision on this institution, as it was between the Council of Trent and the end of the 17th century. The Apostolic Court of Audience, currently named Roman Rota, is the high civil court of the papacy. It comprises 12 judges or auditors, number was fixed in 1472 by Pope Sixtus IV. Three of the auditors were named by the Pope and were usually Romans. The 5 other Italian auditors came from Milano, Venezia, Ferrara, Bologna, and alternatively Perugia and Tuscany. It was a privilege, really, for the states or city to have a seat as a Roman Rota. There were 4 ultramontani auditors named by their respective sovereigns, the Emperor, the King of France, the King of Castile, and the King of Portugal. The King of Aragon, sorry. It means that there were 2 Spanish auditors, but they were chosen according to various modalities, including within Aragon. France had a seat at the Rota but did not send causes to the court, and the same can be said of Venice, Venezia, for example. Well, this variety of origins, which was unique in Europe at the time, was supposed to make the court able to understand disputes arriving from very diverse parts of the Catholic world. The court, judges under papal delegation, and had no competence per se. About 2/3 of the cases arrived on appeal from ecclesiastical courts. Most of them deal with the international functioning of the church, ecclesiastical benefices, tithes, precedence among clerics or churches, validity of religious vows and of marriages, although these kind of causes are not very frequent, and so on. In theory, cases came from across the whole Catholic world, but in practice, they came mainly from Italy, and although not all Italian states, Spain, Portugal, but not the Iberian empires, which were under the regime of royal patronage. And sometimes causes came from German Catholic states and Poland, until Poland at this time. The Rota was also an appeal court for the civil courts of the Papal States of Rome, Papal State and of Rome, judging so-called secular cases in which a minimum amount of 500 scudi was at stake. These cases accounted for more than 1/3 of the Rota's activities, more or less. In this category, one would find cases on inheritances, contracts, houses, dowries, on the application of the statutes of Rome, and a large set of issues. In addition, the Rota dealt with causes in first instance, in practical terms, when a cause was delicate and important for the Holy See, but not to the extent that the Pope would personally deal with it. He entrusted it to the Curia, especially to the Rota, whose auditors were qualified for this task. Let me give an example of this, and it's an example that I treat in my book. In 1587, there was a big scandal in Rome about the bets on the promotions to cardinalate. The totally unexpected nomination of Cardinal William Allen, of the English William Allen, to cardinalate in August this year, in contradiction with the Pope's recent decree, caused the ruin of many gamblers and strong protests in Rome. Sixtus V entrusted the case to Auditor Lorenzo Bianchetti, so that the final decision came from the Rota and not from the Pope himself. Each cause was entrusted to one of the 12 auditors, who became the opponent, the rapporteur of the cause, and followed it from the beginning to the end. If the rapporteur left the Rota due to his death, transfer, promotion to cardinalate, or whatever, the dean of the Rota entrusted the cause to another rapporteur. Appeal was only possible before the Rota and with another auditor. Each cause was named according to the diocese of origin of the dispute, the subject matter, and sometimes by the name of the family involved. The word causa is implicit. This way of naming causes is not particular to the Rota at all. The litigants' family names are often omitted in the printed decisions, and in this case, they appear under their first name or their title. The Count, the Duke, and their first name, yes. So my Boncompagni file, what I will present you, comprises 6 decisions on the Romana Dotis de Boncompagni, the Roman cause of dowry, and 3 decisions on the Romana Pretensi Erroris Calculi, the Roman cause of alleged miscalculation. The Rota would meet on Monday, Thursday, and sometimes Wednesday behind closed doors. By order of seniority, since joining the court, each rapporteur would submit to his colleagues a dubium on the cause he was following, And the dubium is a question whose answer was always yes or no. Previously, the opponent, the rapporteur, had studied the files, allegations, memories, notarial deeds, and any elements of proof given to him by the procurators and lawyers of both parties. It had met to the friends and defenders of social relations of the different parties, and he had reached an agreement with the procurators and lawyers for the formulation of the dubium. In every cause, the issue was to determine if the sentence in first instance, or the previous sentence, because some causes arrived in the Rota after a very complex past, was to be confirmed or not. But the objective of the court was not necessarily to cover all the way to the sentence. Every effort was made to convince the litigant to accept an agreement before arriving to the sentence. Hence, a cautious and very slow procedure where the different issues raised in the cause were examined successively. The function of the dubia, then, was to break down the dispute into as many segments as was necessary in order to secure the legal solution. Meeting in session, the court examined current cases. Each auditor could report on a maximum of 2 cases per session. During the session of the Rota, the rapporteur proposed a dubium to his colleagues. Usually, the discussion involved only the 4 auditors sitting at the left of the rapporteur, who were named his corresponsales. Only the most important causes generated a general debate. The corresponsales, there was a discussion, and then the corresponsales gave their vote to the rapporteur, yes or no, and, which is a capital point, the motivation of their vote. The rapporteur himself didn't vote, but after the session, the rapporteur, with his assistants of course, would write a text called decision, where, after a brief presentation of the dispute, the fact, he explains the reasoning leading to the answer to the dubium. He presented the diverse arguments, quoted authorities and the jurisprudence of the Rota, and rejected the argument of the opposite party. Thus, the Rota was the unique court at the time whose decisions were motivated by the judges themselves. These texts, the Rota's decisions, were sometimes masterful pieces of legal literature. Their form changed radically just after the Council of Trent. They became much longer and much more explicit in the exposition of the Rota's reasoning. They were no more they followed no more the classification of the decretal, but they followed the classification by diocese and matter. Those decisions were written with very carefully because they circulated a lot. First in manuscript copies, and then in printed volumes collecting the decision of one single auditor during his career at the Rota, of the decision produced by the court during a certain lap of time. The collection of decisions of the Rota beginning approximately in the last years of the 16th century. They are very numerous until the years 1720, and then from the second part of the 18th century, the institution itself begins to produce every year a collection of Rota decisions, and the circulation of information is much more organized. On the other hand, the manuscript documents that had been used during the procedure were carefully archived by the auditor's assistants and kept in thick bundles sorted by year. Well, how did I proceed with this material, which it will be the second part of my presentation. By browsing through dozens of collections of Rota decisions in search for demands of nullity of vows or marriages, I noticed this Roman cause of dowry of Boncompagni because its main protagonist, Hugo Boncompagni, was a famous neophyte at the end of the 16th century, and having worked on conversion, well, naturally I was interested by this case. However, the Rota rarely dealt with Jews. You can find in the causes some Jewish merchants of Ancona, some of the ghetto's inhabitants in causes about testaments, houses, even a case of an accident and a cause of individual responsibility. Well, but it was unexpected to try to say something about the Jews of Rome and neophytes of Rome from the sources of a tribunal, which was not a religious tribunal. Step by step, I reconstructed the whole family history in order to understand this dowry case. To sum it up, here is the history of the family. Between 1566 and 1605, about some 40 members of a family of Jewish bankers of Rome, the Corcos, Sephardic bankers, were baptized under the patronage of the popes, forming a new family in Roman nobility, the Boncompagni, which is the name of the Pope Gregorio XIII. The heads of the family, initially pawnbrokers in the ghetto, baptized with highly advantageous social and financial conditions, became powerful businessmen, adopting a patrician way of life. With the support of the authorities, they gradually brought nephews, wives, and children out of the ghetto to broaden their socio-economic base. But the violent condition of baptism, financial pressures, arrest, abduction of children, led the Boncompagni to litigate before the Rota in order to settle the disputes over the distribution of wealth between the head of the family and the others. Well, that's the result of the historical reconstitution. Well, now the research. The largest part of my corpus is made of 6 decisions on the Roman cause of dowry of Boncompagni, la Romana dotis de Boncompagni. The first 2 decisions, dated 10th of December 1668 and 6th April 1609, have been written by auditor Francesco Sacrati Damasceni and published by Prospero Farinacci in his collection of Sacrae Rotae Decisionum Recentiorum. The last 4 decisions, dated from January 1613 to April 1614, written by auditor Giacomo Cavallerio, were published in the collection of his decision in 1629. This list gives an idea of the length of the case. Most cases could be resolved in 3 decisions, it's an average number, but some of them lasted much longer. The longest case on my documentation on consent is a Portuguese cause of nullity of religious vows, which required no less than 11 decisions over 7 years, and the total duration of the trial is much longer because before reaching the Rota, the Portuguese nun had exhausted all possible legal proceedings in Portugal. She, to settle the chronology of this case, this Portuguese nun entered the convent at the age of 11 in 1605, and she obtained a favorable sentence from the Rota in 1646. And she could go out from the convent. Well, the decisions, or the written decisions, the final decision written by the auditors, only give minimal information about the family dispute. the exposition of the fact is limited to what is necessary to the legal solution of the dispute. So reading the printed decision is not sufficient to understand the complex history that originated the conflict, because it was not the interest of the auditor to make the whole reconstitution. They didn't have to care about it. So I proceeded as follows. Starting from the printed decisions collected in Prospero Farinacci and then Cavallerio, I tried to find the handwritten booklets containing the positiones causarum, which is the summaries, lawyer arguments, excerpt from witness statements, copies of notarial deeds, etc. And this manuscript documentation of the positiones causarum provide a huge amount of information about the context of the dispute. It's not always possible to have access to the sources because a large number of them have disappeared. And moreover, there is no detailed inventory of the causes kept in the Archivio di Stato di Roma, font which covers the first part of the 17th century, and for the second part of the 17th century, the fonts are kept in the Archivio Vaticano, where there is an inventory. Ideally, one should also find the trial in the first instance, but in the 10 cases of consent that I have reconstructed, I have never been able to find all the documents at one time for the same cause. In general, I was unable to locate the first trial. This means that a big number of trials in various dioceses, which records have not been preserved in the diocesan archives of Spain or Portugal, for example, can only be known thanks to the Rota fonts preserved in Italy. And so that would be interesting for historians of Spain and Portugal, because they can learn more with the Roman documentation on the Rota. Well, that was the second step of the research, the positiones causarum. And then in the third step, I searched for the notarial deeds mentioned or copied in the positiones causarum. For the Roman cause of dowry, this method produced incredible results. I was able to verify the accuracy with which evidence was mentioned and cited by the auditors and their assistants. So in the fourth step of the research, I proceeded by searching the archives of the notaries of Rome for the notarial deeds that were mentioned in the procedure, and then I extended my research to other notarial fonts, Banchieri Ebrei, Notari Capitolini, Notari della Camera Apostolica, and with this documentation, I tried to reconstruct the situation of the Jewish community in Rome in the years 1560 to 1610, because it is a period for which the Jewish community of Rome is not very well known. Most studies study the beginning of the 16th century or the second part of the 17th century. Well, this work kept me quite obsessively busy for 6 years, and it gave me the opportunity to shed a new light on the history of the conversion of the Jews in Rome, a topic which had been studied mainly from the documentation of the House of Catechumens and Holy Office or autobiographical text. Well, in the Roman cause of dowry, the plaintiff, Flavia, which is age 16 and of marriageable age, demands that her grandfather, Ugo Boncompagni, pays her dowry on the grounds that she is poor and without financial support from her Jewish family, while her grandfather, Ugo Boncompagni, is very rich. Ugo Boncompagni then was a famous neophyte, baptized in 1582 in St. Peter under the patronage of Pope Gregory XIII, who gave him his name. Ugo Boncompagni was born Salamone Corcos, a prominent member of a great Sephardic family and the richest Jewish banker of Rome at this time. He left the Jewish community to follow his son, Lazzaro Corcos, baptized 1 year before with his wife under the spiritual patronage of Filippo Neri. It is related in Filippo Neri's biographies. Lazzaro Corcos received the Pope's name, Gregorio Boncompagni. Unlike the numerous conversions of Jews which took place at this time of strong conversionist pressures on the Jews of Rome, father and son became famous because of their personal link with the Pope and the protection of the young congregation of the Oratorians founded by Filippo Neri. The Boncompagni, neophytes, Boncompagni, they settled in a palazzo near the Chiesa Nova or Vallicella. You can see a palazzo, Piazza dell'Orologio, if you know Rome, where it's written Corcos Boncompagni, but it's not the palazzo of this generation, and there is no reason to call it Corcos apart from a memorial reason. Well, the Lazzaro, Ugo and Gregorio Corcos Palazzo was near the Chiesa Nova or Vallicella in the Rione Parione. Their palazzo were near the Orsini place too, and it's important because their aristocratic patrons were the Orsini. So Flavia was the daughter of Hugo's daughter, Deborah Corcos. In the beginning of the case, so the rapporteur was Francesco Sacrati, native of Ferrara, who had been an auditor since 1599. It did not take much time for the Rota to decide that Ugo, the rich grandfather, had to give Flavia a dowry in subsidium. It means in the absence of other parents who had to pay normally the dowry. And those parents was the late father of Flavia, Isaac, and her two brothers, who were alive but very poor. And the Rota decided very quickly then that the dowry was to amount to 1,000 scudi. But the Boncompagni raised multiple objections. They contested that the fact that Flavia's Jewish family was poor. They tried to reject the Jewish witnesses on the Jews' poverty, and they negotiated the amount, alleging that Hugo's numerous Christian grandsons and granddaughters were for him a very heavy burden. The court was not convinced by this objection, and each time for this conclusion there is a series of arguments. No? On the contrary, the Rota justified the amount of the 1,000 scudi by examining carefully Flavia's condition. This examination is very interesting of how those churches could see the Jews and a Jewish neophyte like Flavia. On one side, they say her Jewish origin and non-noble condition would not let her pretend to a very consistent dowry. And they had to take into account to Hugo's financial constraint. But on the other side, the amount of 1,000 scudi could not be reduced because Flavia's Christian family was noble, and being a neophyte, Flavia needed an attractive dowry to marry a Christian because she had to compensate her Jewish origin. There is no limpieza de sangre in Italia, but you can see with this notation that there was a prejudgment against the Jewish origin. It is remarkable that in these reasonings and in the whole decisions, the circumstances of Flavia's conversion were never explained, and it was a whole mystery for who read those decisions. Because it was surely not considered important for the resolution of the case, which was for the Rota a case of dowry in subsidium like other cases. But the difference was the problem of Jewish witnesses. About Flavia's family lack of financial resources, the court received witnesses of Christians, neophytes and Jews, as well as copies of notarial deeds. Religious affiliations here were very important because, according to common doctrine, Jews were not reliable witnesses, and churches were not supposed to accept their deposition except in heresy trials. But in Flavia's case, it appeared that the information provided by Jewish witnesses was much more precise and up-to-date than the one provided by Christians and neophytes who have left the ghetto many years ago. So, although the ghetto was only at a short distance from the Vatican, where we have to believe that the meeting took place, it was for the auditors a very unfamiliar place. We can see that they had some general notions about the Jews' legal institution. They knew, for example, that Jews sold their gazagas, that right of perpetual hunting on their houses in the ghetto, only in case of extreme poverty. But to collect precise information of the Jews' poverty or richness, the auditors observed that they could not do without Jewish witnesses. Well, the frame of the Rota solution was fixed when the cause was interrupted, probably by Hugo Boncompagni's death in 1609 or Gregorio's death 2 years later. In 1630, the trial resumed his course, this time before Auditor Cavallerio, because Sacrati has been promoted to Bishop of Damascus. Flavia's adversaries were now the heirs of Hugo and Gregorio Boncompagni. They appear to be very hostile to Flavia, but the reader of the decision have an impression of déjà vu because the arguments are repeated once and again. Because the Rota had to do with the stubborn refusal of the parties to accept the solution proposed by the Rota. So the arguments were repeated again and again, and Flavia's lawyers were claiming a part of Gregorio and Hugo's inheritance. Nevertheless, the Rota obtained that the Boncompagni constituted a reserve in Loghi di Monti to pay the dowry, and they insisted that time was running and that a solution had to be reached before Flavia was too old to find her husband. Thus, this gave an idea of the passions of the Rota. This court is very patient because they want to exhaust the resistance of the parties, and but when one of the parties was visibly maneuvering to block the procedure and making obstruction maneuver, always came a moment where the court imposed its authority. I have no information about Flavia after the conclusion of the cause, but she obtained the mille scudi, which was what was decided from the beginning, but it was very long, a long way to arrive until that. I will be more brief on the other sources, but with those sources, I knew nothing about Flavia's conversion. How did she became a Catholic? But providentially, a random search in the index of positiones of the Congregation of the Council led me to a decision of a special commission of the Congregation dated 15 September 1605 concerning the restitution of a boy, Angelo, age 4, abducted from his Jewish father and mother, Joseph and Deborah Ascarelli. The brief report of the Commission was attached to a collection of petitions presented by the Ascarelli's lawyers relating the circumstances of the abduction and demanding the restitution of the boy. On the opposite, an anonymous author, probably an oratorian, argued that Angelo was willing to become a Christian. He was at the age of 4. Huh? This document gave me the keys to the beginning of the Roman-Adotist cause. Flavia was abducted with Angelo and their brother and sister. She was Angelo's elder sister, born from Deborah's first marriage. Boncompagni, her grandfather, was not the one who had taken the initiative of bringing the children from the ghetto. The violent condition of the children's kidnapping created an abnormal situation, as their Jewish father and mother stayed in the ghetto and did not provide for their expenses. As a result, Flavia had to sue her grandfather to obtain her dowry. So this was a very important information. The decision of the commission itself is hardly understandable out of context but on the 12 cardinals who seated in this commission, a majority had strong relationship with the oratorians, and one of them, Francisco Maria Tarucci, was himself an oratorian, and some members of this commission who had a strong spiritual links with the oratory or brothers in the congregation, and Tarucci had participation to the baptism of Isaac Corcos, which was a cousin of Flavia. And even Cardinal Paolo Emilio Zacchia, head of the congregation of the council, was the godfather of another nephew of Ugo Boncompagni, Paolo Zacchia, the future pioneer of forensic medicine, baptized 6 years before, and I found his baptism act. Well, little by little, I could reconstruct now the history. So I will be more brief on two other causes. In this family, Ugo Boncompagni had a brother, Jacob Corcos, and Ugo Boncompagni had only one son, but his brother Jacob had 6 sons. And in 1592, after Jacob's death, Ugo Boncompagni took 4 of his nephews, the youngest of the 6 nephews. He took them from the ghetto and he led them to the Vallicella, to Filippo Neri, and the 4 young boys were baptized. They consented to baptism, and this history is known in the big history, great history of Catholic Rome, because it is written and related in the deposition for the process of the canonization and beatification and canonization of Filippo Neri as a kind of miracle made by Filippo Neri. And that's how the Corcos arrived in the history of Catholic Rome. But after that, the 4 young Baptists grew older, and years before, they maintained a constant pressure on their elder brothers, Salvatore and Isaac. And Isaac was the first who converted, and then at the end, Salvatore. Well, the cause of alleged miscalculation that I find in the decision by Alessandro Ludovisi, future Pope Gregory XV, gave me a key on what happened in this among those brothers in those years after the youngest conversion, and they give me important information on the pressure who led finally Salvatore to be baptized under the name of Michelangelo. Without telling all the story, which is remarkable here, what is remarkable here is that in the written decision, there is not the name of Boncompagni, and the title of the cause, the alleged miscalculation, doesn't let us suspect that it is about the Boncompagnis. It is only because I read the collection of auditors, the auditor Ludovisi's decision. It's not a novel, but I love to read the decision. And I've seen the names of the protagonists, Michelangelo, Alessandro, and so I recognized that it was a part of the history of this family. And then I found another cause, the Roman cause of guardianship of Boncompagni, Romana tutelae de Boncompagni, with a unique decision before Auditor Ubaldo in 1615. This last cause give invaluable information about the Boncompagni family after Hugo and Gregorio's death. Gregorio had married in second wedding a woman of impeccable Catholic and noble origin called Lisa Burati, whose brother is well known because he was a military engineer and he worked in particular in the Castello Sant'Angelo. And Lisa Burati became the stepmother and the legal guardian of Gregorio's children. Well, Gregorio's elder son, Baltasare, sued Lisa Burati, claiming that she had faked the theft of her jewels and 2,000 scudi in order to remove them from Gregorio's succession and estate. Indeed, I find the corresponding trial before the criminal court of the governor of Rome, and it shows that Lisa's money and jewels have disappeared, but the theft is not proven. Lisa was noble and Catholic, but she was not a very scrupulous woman, apparently. It's a fascinating trial because we can reconstruct how Lisa was dressed, jewels, that they had vigna outside Rome, and all the lifestyle of the family, and also domesticity of this family. That explains why the end of the Flavia stories cause was so long, because the heirs of Hugo and Gregorio Boncompagni had no affective link with Flavia. So the end of the trial is very passionate, and it's only for money, and it explains the harassment from the parties. Well, this work, to conclude, is just an example of how the sources of the Roman Rota can give new light on certain context and permit case studies. It is a good example of how the Rota worked. The cost of the procedure is not so heavy in Rome because you don't have to pay translations, and but it is important to see that the procedure is so patient because there is a strong security in the decisions of the Rota, but the decisions are only one little part of what the real history of the dispute was. Well, I hope you were interested. Thank you.
Thank you very much.